Ladies and gentlemen, the event will now begin. Kelly, please go ahead.
Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, The Importance of Security and Integrity Issues Within the Virtual ADR Process. This event is brought to you by Law.com and sponsored by National Arbitration and Mediation. Before we begin, I'd like to go over some basic housekeeping items to help you use the webcast console throughout this hour. First, the event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console without having to open a new browser. Just scroll along the bottom of the screen and click on the social networking widget of your choice. If you have a question for our speaker today, please enter it in the Q&A widget on your console. We will get to your question either during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so please feel free to ask away. And if we don't get to your question within the hour, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So if you'd like to change the look and feel of your console, please go right ahead. Also, this event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. CLE credit is available for attorneys in the approved jurisdictions, provided that you have viewed this event live for 50 minutes or more. Participants who wish to receive credits for other states must check directly with their CLE board. Within an hour after the presentation, all attendees will receive further instruction via email on how to obtain your CLE. The CLE code will be announced during the presentation. New Jersey and New York attorneys should be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. The certificate will be available for download 1 week after the event on June 18th. And now for today's topic and the reason you were all here. Teleconferencing and videoconferencing are hot topics in today's environment. Legal professionals are using this form of communication now more than ever, heightening exposure to cybersecurity threats. Here to address basic protocols and guidelines to help minimize security concerns surrounding virtual proceedings is the Honorable Judge John DiBlasi. Judge DiBlasi's career includes 10 years spent as Justice of the Supreme Court, Commercial Division, where he resolved hundreds of matters. In 2020, for the 7th year in a row, Judge DiBlasi was named one of the top 3 mediators in the United States by the National Law Journal Best of Survey. He was also voted #1 mediator in the U.S. by the 2018 Corporate Counsel Best of Survey, and for the 3rd year in a row, was named a National Law Journal Alternative Dispute Resolution Champion as part of a select group of only 46 nationwide. So Judge DiBlasi, thank you for joining us today and welcome.
Good to be here.
And before we dive into today's discussion, we'd like to gather some feedback from our audience. And to do that, we're going to ask 3 polling questions. So if you can all kindly respond as we show those questions on the screen, that'd be great. The first question we have here in front of you, as you can see, is how many mediations or arbitrations have you participated in the past 12 months? And you can mark your selections by clicking one of those radio buttons and then hitting the submit button on the right-hand side. Either 0, 1 to 5, 6 to 10, or over 10. Okay, let's advance to our results. Okay, we have just over half saying 1 to 5. That's great. The next largest percentage is 6 to 10 at 15%. All right, for the second question, we'd like to know, for comparison's sake, how many virtual mediations or arbitrations have you done in the past 12 months? 0, 1 to 5, 6 to 10, or over 10. Again, select one of those radio buttons if you would, and hit the submit button to the right. Okay. And about 66% responded 1 to 5, with actually 0% saying more than 5. Okay. And for the next question, this is the final question, we'd like to know, have you used any of the following platforms for any business purpose? And this is a select all that apply. So any that apply to you, please feel free to mark here. Either Zoom, WebEx, BlueJeans, or Skype. Assuming most of those are probably rising in popularity today. All right, and we'll move along to the results. Okay, a vast majority responding with Zoom, close to 100% actually. WebEx, 44%, Skype at just over 50%, and BlueJeans taking the narrow 3.8%. So great, that's great. Thank you everyone for your input on those questions. These responses will definitely help to drive the discussion today. So at this point, I'll go ahead and I'll pass it over to Judge DiBlasi to get us started.
Well, good afternoon, everyone. I'm going to try and make it as interesting for you as possible today. As a matter of fact, I had one of your colleagues who's listening on a mediation earlier today, and she told me I better make it interesting because she'd be listening in, so I'll do my best. You know, it's interesting to hear the results of the four background questions, as I'll call them, because I'm going to make two comments about it. Just in terms of my background, I've done over 5,000 mediations and arbitrations in the last 13 years. And in the last 2 months, I think I'm closing in on 200 virtual and arbitrations and mediations. And I'm not telling you that to impress you, but the thing that I'm going to say to you is, first of all, you know, my perspective of this is of someone who does this day in and day out the entire year. But more significantly, what I want to say to you about this before I get into the meat and potatoes of the presentation is that things are changing. And when I first started lecturing about this topic about 2 months ago, I said to people that this is going to change week by week, you know, month by month. And it's radically changed within the last 2 months to 3 months because of the fact that there is mass acceptance of the technology and the people who are using it are very satisfied with it. And I will tell you right off the bat, I am not a cybersecurity expert, but I've developed a very good understanding of the process and the security protocols that should be in place. I've done this actually for many years. When I say I've done this, I mean virtually for many years prior to this. And I'm going to make you a prediction. I think ADR as we know it, face-to-face, you know, I honestly believe that even after the pandemic is over, that ADR probably is going to be done virtually more so than face-to-face. And I'll make you another prediction as a former Supreme Court justice. I believe within 10 years, you're going to see such an advance in the technology that probably you're going to have very limited court appearances, and they will primarily be for trials or hearings that would involve the taking of witness testimony. That's my prediction. You know, we'll see how it turns out in another 10 years. But the interesting thing about this is that current circumstances, you know, really made face-to-face mediations and arbitrations impossible. And the fortunate thing with NAM is that this was not a quick fix for us. We had been doing it for years. We were familiar with the technology, and we were ready to jump in immediately, and in fact had a game plan to jump in immediately once everyone was told to shelter down. Now, one of the things that I've seen come up over time is that, you know, it's difficult for people to accept change. But this is an opportunity really to try something new, and as I said, has been enormously successful. And when I talk about accepting change, I remember many, many years ago when word processors, I hate to tell you, I've been practicing law 40 years as of August of this year, word processors were a radical change, and at the beginning, a lot of people were afraid to embrace them. And I guess, you know, really giving away my age with this, because it was such a radical and new concept. But, you know, by way of background, this technology is not new. It was not set up to address, you know, the current crisis. At least NAM had it in place, and I had used it in mediations and arbitrations. But when you talk about this, and I again go back to the poll questions, you know, there are certain things that we really want to look at to try and help you in this process. And the issues that I see come up over and over again is, you know, what is virtual ADR? How does it work? What are the benefits? And really that sort of frames the conversation that we're going to have. And there are a lot of interrelated topics here, which is interesting. And at times as a presenter, it's very challenging because I have done this in many different ways to tailor it to the audience that I have. But the same issues really keep on popping up over and over again. The fear of the new technology, virtual ethics, people are very concerned about that. Virtual security, people are very concerned about that, and rightly so, by the way. And the mechanics of how this actually works, besides just getting into the platform. Now, in terms of the fear factor, the things that we're looking at more specifically are how do we ensure, the integrity of the proceeding itself. In other words, while we're conducting the mediation or the arbitration, how do we ensure that it is conducted as it would be if it were face-to-face? And, of course, people have a bit of a concern about that because they can't see the people in front of them as they would, for example, in a courtroom or in a mediation that was face-to-face. How do we know the technology is secure? And, of course, everybody is right to be concerned about that. And what I will say is I'm going to talk specifically about the security protocols that NAM has in place. And what I'm going to do is dovetail that with what you should be looking for with any ADR provider that you're working with, and also dovetail that with if you are using any type of online platform, in terms of user hygiene, or in other words, protecting yourself, what you should be doing. And then I have a lot of people who completely freak out the first time they get onto a virtual mediation and arbitration because they're afraid of mastering the technology. And, the interesting thing about that, what is that all about? Well, we don't want to be embarrassed because we can't master this technology. And I'll tell you, I was freaking out a little bit before we started the presentation today because we were working through the technology of setting the presentation up. And sometimes even for someone like myself who works with this every day, it can be daunting, and, that's understandable. But in terms of the, fear factor, we have to look, at ethical guidelines for the conduct of virtual proceedings, the safety of the technology, and not just the safety of Zoom. And I know many of you have used Skype. I know in terms of the New York State court system, they're using Skype. Blue Jeans, small percentage of you have used that. WebEx, and then we have Zoom. NAM has all of those platforms, and I'm familiar with all of them. So we go from that in terms of the type of platform and whether it's safe, and then the use of the technology itself. One of the things that people started to express to me very early on was, well, I'm doing this virtually. Now, how do I know it's really safe in terms of the ethical practices? And one of the things that came up is someone said to me, well, how do I know someone is not recording the conversation that's going on? How do I know that there's somebody else, in the room who I actually cannot see? And I'm going to address all of those issues and how to deal with that. But what I said to the majority of people that raised this question, I said, look, anytime you're dealing with ethical conduct, particularly in ADR, and in actuality, in any part of the litigation process, it's based upon trust, and it's based upon attorneys acting ethically. As I said, there's this, I guess, false impression that attorneys have that somehow it's going to be easier to act unethically if you're in a virtual arbitration or mediation than it is if you are face-to-face. Now, I'll tell you that's not true. You can have people act unethically, and I've seen it at face-to-face mediations and arbitrations. But interestingly, I have never seen that on the virtual side. And I'm beginning, I wish I was a psychologist and I could try and start figuring out what's actually going on. But I'm finding that in the virtual process, maybe because we have to look at each other in the eye at all the time, maybe it discourages a lot of the grandstanding, a lot of the maneuvering, and other things that go on in a face-to-face mediation. Not to say that the majority of attorneys, there are many attorneys who act unethically in a face-to-face mediation or arbitration, but, it happens. So there's some ethical issues that are, however, specific to virtual ADR, and I'll discuss them as we continue. But, the thing that you have to remember, whether you're dealing with, a face-to-face mediation or arbitration or a virtual mediation or arbitration, the rules are the same. The interesting thing to me, having been a judge and in my prior incarnation, a trial lawyer, it's interesting to me in terms of ethical conduct in a courtroom, and I was thinking about it today. Most court proceedings, you're going to have a record. a record is something that is a safeguard against unethical conduct in the courtroom, in a court proceeding. The record is always there. What's being said is being taken down. So if there is ethical misconduct in a litigated proceeding, it's first of all deterred by the fact that there's a record, and obviously by virtue of the fact that there is a record, if it's the type of conduct that creates some type of error that could be reversible, for example, in a trial, there is an appellate process that you can go through. The ADR process is an entirely, different animal because there is no enforcement mechanism per se, in terms of a record that would safeguard the proceeding. And what you have is, a mediator or a neutral, and depending upon how involved that mediator or neutral is, a lot of times I think as I am, I'm a very friendly, diplomatic person, but I'm very alert as to anything being said or done that would be inappropriate in any way. But the thing that you have to remember, whether you're face-to-face or virtual, and I would suggest, and I would almost bet that the majority of the attorneys who are listening, and I hope I'm wrong, but I would guess that the majority of attorneys who are listening have never sat down and read the ethical guidelines for settlement negotiations that are promulgated by the section of litigation of the American Bar Association. You should sit down and read those. They go in detail from point A to point Z as to what your obligations are in terms of conducting a good faith negotiation. And of course, the entire purpose of the virtual ADR process with respect to mediation is conducting a negotiation in good faith. So whether you are face-to-face or whether you are virtual, the fact of the matter is the same ethical obligations apply. And it's very, very simple to find out what they are. Negotiating in good faith. What do I mean when I'm talking about that? Virtually or face-to-face. It's sometimes easier to explain, and I always say this, good faith by telling you, what is not good faith, okay? A good faith negotiation does not include omissions. In other words, if someone asks you to make a representation with respect to a settlement offer or with respect to particularly conditions of settlement, the classic situation is you go through a very long monetary negotiation and there are no conditions mentioned, and then you get to the end of the monetary negotiation and there's an agreement, and all of a sudden, oh, by the way, there is a condition that attaches to this settlement beyond the monetary and beyond the other conditions that we've discussed. That's bad faith conduct by omission. False representations. You can't represent falsely in a mediation. Does it happen? Yes, I've seen it happen. False statements. You can't make false statements in a mediation. Now, of course, during the negotiation process, you're going to say to me, well, there's bluffing involved, there's gamesmanship involved in any negotiation. That's absolutely true, but that's not what I'm talking about. I'm talking about someone who says to the mediator, find out if the other side will accept X, Y, Z with respect to the settlement. The mediator speaks to the other side and says, will you accept X, Y, Z in terms of the settlement? And then comes back and speaks to the party that they originally were speaking to, and they say, well, we really didn't mean that. We really don't have our clients consent to settle in that fashion. That's what I'm talking about. Coming into a mediation with no intention of settling, obviously bad faith. Changes in pre-mediation demands or offers, whether you're virtual or you're face-to-face, the same thing. No intention, of coming in and negotiating against pre-mediation demands or offers, and also the last and most important thing, acting outside the scope of your authority. Obviously, that would be bad faith. Now, in virtual ADR, there are some specific areas of concern, and I will tell you that as I muddle my way through the many virtual mediations and arbitrations I am doing, I am sure that other issues are going to come up. But to date, I have been analyzing every proceeding that I've been involved in to see, where is the possibility of an ethical breach here? What could create a problem? What are areas of concern? So there are really some significant areas of concern that I will tell you I have not had a problem with, but it's an issue that I always raise at the outset of any virtual mediation or arbitration. Who is in attendance? Is a witness in an arbitration or mediation being prompted, or are they using, I'll add to this, any exhibit to refresh their recollection? And lastly, is the proceeding being recorded? And I do not mean by the ADR provider, and I'll talk about specifically what NAM does with respect to that. I'm talking about by a person who's participating virtually, who's using some type of device to record mediation or arbitration. So once you log on, in terms of who's going to be in attendance, for those of you who've done a virtual proceeding, you're going to see everyone who is participating. However, the picture, and I know all of you probably have used Zoom or some other online platform, is relatively narrow, and it becomes narrower the more people who come on to the screen. And also, some people do opt not to use a video camera, or they call in and they cannot be seen, because on the platform that we use, for example, you can come in by video conference or you can come in by teleconferencing. You have the same benefits either way. In a joint or breakout session in a mediation, you will know who is in attendance, whether it's face-to-face or virtual, okay? And both the mediator and the parties have a right to know who is in the virtual room. And it obviously would be unethical, to conceal the fact that there are persons who cannot be seen, other than the announced attendees who are listening in. And that's something, have I seen this happen? No. But is it something that occurs to me as a mediator or an arbitrator who's concerned with the integrity of the proceeding? Yes. The requirement is there to disclose all persons, much in the same way at an arbitration. Again, this takes on more significance because you're dealing with a witness. And the issue that usually comes up, or the way it usually pans out, is the attorney is in one location and the witness is in another location. So you really don't know who is in the room with the witness, and there's a concern that somebody could be prompting that witness. And obviously, you would have an ethical obligation to disclose if anyone else is in the room with the witness other than counsel. Now, for example, a family member, a coworker, a supervisor. So there's an ethical obligation to disclose if there's someone else in the room, certainly when a witness is giving testimony. And I'll tell you, it's so interesting how, this is being used in arbitrations. I had an arbitration a couple of weeks ago where a state trooper could not come in to testify at the proceeding. They didn't want to release him for an entire day to testify at the proceeding, but his commander had him testify from a state police vehicle on his iPhone. We knew certainly he was the only one in the vehicle, but the point is everybody's concerned about who is in the room with the witness, if anyone. And if there is someone, that has to be disclosed. And the last thing is, if a document is going to be used to refresh someone's recollection, there's obviously a duty to disclose that. Now, a lot of this can be avoided if the client is in the room with the attorney, but assuming that the client is not. And in actuality, that's one of the big benefits of virtual mediation arbitration is you don't have to worry about people traveling. If your client has difficulty getting to the location, if you have difficulty getting to the location, it lends itself, that's one of the benefits of it, that people can participate and be a witness or participate in the mediation or arbitration, whether it's a company representative, which they would probably not have the opportunity to do in many cases when it's face-to-face. In terms of surreptitious recording, I'm talking about not the ADR provider recording, but I'm talking about an individual saying, well, I have a mediation, I've got the joint session going on, I'm going to record this. I'm in a caucus session with the mediator, I'm going to record this surreptitiously. I'm in an arbitration. It's one thing to have a court reporter who's present. That's fine. That must be disclosed. But you can't surreptitiously use a recording device of any nature to record the proceeding. That would be completely unethical. I am not saying to you that this is going to happen, but I always think proactively as a mediator and as an arbitrator to make sure that the integrity of the proceeding is as foolproof as possible. I'll use those words. So what I always do, and this is what I've done from the very beginning, I ask everyone, is there anyone else in attendance who cannot be seen on the screen who is listening in or somehow participating in the proceeding? Okay? And I also, at the inception of the mediation or arbitration, I tell the parties that the proceeding may not be recorded. Now, if I happen to know all of the attorneys who are there, and it's obvious to me that there's no one else there are times when I don't have to do this, but clearly this is something that I'm very aware of and something that should be done. In terms of the arbitration, the arbitrator, must instruct the parties that no one is to prompt a witness, and also that if any document is being used to refresh the recollection of a witness, because obviously a person could be sitting at a desk like I am now, you can only see me or see a certain portion of my body. I have documents in front of me which you can't see. There should be an instruction to the parties in the event of the use of a document to refresh recollection that be disclosed. And with respect to all of these instructions, all I would say to you is this. If the mediator or the arbitrator doesn't give the instruction, and this is something that's a concern to you many times, though, you know all of the people who are involved in the mediation or arbitration, it's not necessary. But if it's a concern to you and the mediator or arbitrator has not done it, ask the neutral to give those instructions. It's very, very simple. And by the neutral having given those instructions with that authority, I'm sure it would prevent any ethical lapse. Now, in terms of security concerns, and one of the things that I'm going to say to you is that, again, I'm not a cybersecurity expert, but I have been heavily involved with this aspect of virtual arbitration mediation from the onset, and specifically I'm very involved with NAM's security protocols because I want to be assured as the arbitrator or mediator that my process is safe for the parties who are involved and that confidentiality is maintained. But we know, is any system foolproof? Absolutely not. I mean, every day it seems I look at the newspaper and some other major corporation or financial institution in the credit card industry or the banking industry, Wells Fargo, Marriott, Sony, and the DNC. We all know how that turned out in terms of the massive scandals that come out of this with information, emails being disclosed. The point is, it's impossible to guarantee the security of any online activity. That's the truth. But I'm going to say to you generally that I think the risk of a security breach for a virtual arbitration and mediation for multiple reasons is very, very low. And also because of the security protocol specifically that NAM uses, it's very, very low. Now, what do you have to be concerned about? For those of you who haven't gone through these types of things, you've got to be concerned about white hat hackers. Those are the good guys. Actually, you don't have to be concerned about them. They try to find vulnerabilities in the system, and then they tell you how to correct it. There's no malicious intent. The black hat hackers, these are the cyber criminals. They want to exploit vulnerabilities in the system for financial gain. They want to get your personal information, and they want to hack into your computer, or they want to take that personal information and they want to sell it to a third party. The hacktivists or the mayhem hackers, these are really the ones who are the Zoom bombers, they hack websites to expose or disrupt. Now, user hygiene, how do you protect yourself? And I'm just going to stop for a second. I don't know if you want to put in the time break, Kelly, with respect to the CLE program.
Yeah, thank you, Judge DiBlasi. Let's go ahead. We'll read out the CLE code at this time. So the CLE code for today's event is Security 11. That's SECURITY and the number 11. Again, the CLE code for today's event is Security 11. That's with no spaces. I'll pass it back over to you. Thanks, Judge.
Okay, thank you. So here's the thing. First of all, I'm going to talk about how to protect yourself. These are general rules that you should look at. I'm talking about whether you're doing a deposition online, whether you're online for any form of activity whatsoever. These are general things that you should be aware of, because most of the attacks that take place are as a result of a lack of understanding of basic security protocols. Meetings should not be set to public. Meeting links should never be shared publicly. Limit the number of people with access to information or a link and instruct them not to share it with anyone else. And if you have hard copies with meeting information on it, secure those documents. You know, one of the funniest things that came about with Zoom bombing is a corporation that decided to have a virtual cocktail party, and in the middle of the cocktail party, they got Zoom bombed. Well, big surprise, they put the participant ID number and the password on social media. I mean, who does that? Of course you're going to get Zoom bombed. You're not even making it difficult for somebody to do it. And if you want to dig a little bit deeper, two things I'll say to you with respect to Zoom and with respect to computer security. Go on Computer World, go online. There are a ton of articles on it. You can educate yourself. They're very simple. Now, in terms of user hygiene, use waiting room features. Make sure that you use a password, that a password is enabled. And I'll just tell you very quickly why that's important. The way people try to hack into Zoom meetings is they use what's called a digit randomizer. And what they do is get on the Zoom platform. And this is like, you know, the Bourne series movies where they put it up against the safe and it randomly sets forth numbers. And eventually they lock into a participant code and they can get it. Well, if it's password protected, they can't, and they'll move on to the next meeting. Don't allow participants to screen share by default, okay? There should be a host of the meeting. Don't use video on a call if you don't need to. Use the latest version of the software, and don't record the meeting, and most importantly, educate your hosts. Now, specifically, what can an ADR provider do to protect you during the course of this process? Well, when you were coming through NAM, and all I'm going to say to you is I can only talk about NAM. I can't make representations with respect to other ADR providers. NAM is HIPAA compliant. I'll talk about that in a few minutes. When you come into the platform with NAM, you are coming in to what I call a protected bubble. We have licenses. When you are assigned a meeting number, participant number, and we actually don't even do that. You're going to get a link from us. You are coming in to essentially view it as a cement tunnel that no one else for a 24-hour period can access. It's impossible. No one else can. We are not using and reusing virtual mediation or arbitration rooms for multiple cases during the day. You get a room for the day, it's yours, and that's it. They're only, with respect to the links, our meeting numbers and links are different, but you're not even going to see that because when you click on a link, the meeting number and the password are encoded, encrypted, and scrambled. So no one is going to be able to hack that. They're only made available to participants. And being in this room, you know, you can't move from the room that you're in into another case. We don't use generic links. We use two-factor authentication, which is the meeting number plus the password. Everything is also encrypted. There's something else that I'm going to mention here that, you know, came about as we proceeded on with this process. We use a vanity URL, okay? What is a vanity URL? Well, when you log on using NAM's link into the NAM Zoom platform, we have a web address, our own web address, that you are connecting to. So you're not connecting to Zoom. All right? You're not going on Zoom USA. You're going on a NAM vanity URL, and that protects you because you're not really on the Zoom platform. Additionally, when you come into our platform, the link, as I said, is encrypted. So the meeting ID, the password is encrypted. We don't collect any login information. And that means there's nothing to steal, even if someone was to be able to get into this, and the unlikely chance there was a breach, there's nothing to steal in terms of your login information, your email address, your location. And most importantly, by virtue of the fact that we're HIPAA compliant, when you're on our Zoom platform, nothing that goes on in that platform is shared with Zoom. So there's no information to steal. So my point is, if we make it almost impossible for you to get to the NAM Zoom platform in the first place, but then as in the second place, we create a situation by virtue of being HIPAA compliant. I think most of you know what that is. There are very strict security protocols for that. If we make it impossible for you to steal information on that platform, there's no information, and we can't share it with Zoom. Zoom can't get it. Well, how is someone, on the unlikely event that they're going to hack in, get anything? Are they going to listen into our conversations? Well, I don't doubt that anybody is that interested in listening in on an arbitration or mediation. What's more, they'd have to get in a specific time period, okay? So if you book a 2 or 3 hour mediation or arbitration, do you think someone's really looking at that to attack? Well, they can go ahead and try and attack NAM's website, but every possible step that has been taken, vanity URLs, encrypted passwords, no login information, no information collected on the platform, no information shared with Zoom. It makes it pretty hard for anyone to crack into, the NAM Zoom platform. That's what you have to ask other platforms or other ADR providers in terms of what they're doing. Also, are their neutrals trained? Are they updated on security issues? Do they know what to do in the event of a breach? The neutrals act as hosts. They have sole control of the meeting. Okay, the neutrals and the participants are notified when someone enters or leaves the meeting. Screen sharing, okay? No images or files may be shared without the permission of the neutral. You've heard about people putting up obscene material during a Zoom bombing incident. It can't happen if there is no screen sharing without the neutral approving it. And the neutral gets to preview what's coming up on the screen. The neutral can mute, put on hold, remove, or expel anyone at any time. And once we throw somebody out of the meeting, if someone were to hack in, they can't get back in. We're the only ones who can turn video on or off, but I'm going to tell you that video is disabled on the NAM Zoom website. We can't record it. There is no live streaming of it. There is no chat. We've disabled chat. So there is nothing there that's going to be able to be shared or stolen by anyone else. And as I said, screen sharing is paused to allow the neutral an opportunity to look at what's coming in. I've mentioned some of these things. One of the things that comes up over and over again is that everyone is concerned about breakout rooms. And the one thing I said before, I think I've covered all these things. Live streaming is disabled. We can lock a meeting. We control who's on the screen. We can really lock down the meeting if there's a breach. Chat is disabled. But the information sharing is incredibly important. As I said, new information is shared. And the last thing I just want to mention on this part of the topic is that we have an IT department that's very proactive. Ask your ADR provider if they have that. We have at least 5 people on board online at all times watching for security breaches, not listening in on the meetings, and also making it easy for you to log in and work the technology. Once you come on into NAM Zoom's website, all you have to do is log in. The mediator takes over, the arbitrator takes over, and you have nothing else to do. If there is a glitch or a technological issue, that's something that can be corrected very quickly. Now, Zoom, WebEx, BlueJeans, and beyond, Zoom is very popular because it's easy to use. It's totally accessible. You can use it anywhere, and it's very, very simple. You're given an access code, and in our case, you're given a link. And you click on it, and you come right into the meeting. And as I said before, if you're fearful of the technology, which we understand, the fact of the matter is we have the IT department there to help you. They can help you before the video conference or during the video conference or teleconference. Teleconference, you're given a phone number, you're given an access code, you're given a password. It has the same benefits as video. As I said before, some people choose to keep their video off. I guess they're camera shy. You come right into the mediation or arbitration. The neutral takes over as the host. The neutral handles the technology from that time forward. You have nothing to worry about. Now, what will you see when you log on? Well, when you enter the meeting, as I said before, you're going to see everyone in attendance, including the mediator. The name of each party attending will be below their image. One thing I'll say to you, you can name yourself. You'll be prompted by Zoom to type in your name when you're coming in. Put in your full name. Do not use your initials or the name of your company or law firm alone. But if you come in like that, guess what? I can rename you during the session, and often what I'll do is I'll put in the name of your client next to you. So you're in the joint session. Many of you have done Zoom, as we know, and you see this in the joint session. But, of course, at the bottom of the screen, as I said, chat's disabled. Screen sharing you can't do. Recording is disabled. there are a lot of things that you may see them, but you're not going to be able to use them. From the standpoint of the mediator, this is what I'm going to be seeing, and this is how I'm going to be moving people back and forth into breakout rooms, which is really always a big topic of conversation. And again, you can see what's coming up on my view as the host to move people around. This is your view. If you look at the bottom, you'll know who the participants are on. Screen share is disabled. Chat is disabled. Record is disabled. The only thing that's important is ask for help. People say to me, once I'm in a breakout room, how do I get you? Click on ask for help. It sends me a message, you need me. I come right into the room. There's always a chime when I enter, so I can also message you and say I need to speak to you. Never press leave breakout room. That ejects you into hyperspace. That's just a little practical tip. So you use the ask for help, and it calls the mediator back in. Breakout rooms are secure. If I was going to talk about any question that's been asked over and over and over again, are breakout rooms secure? Yes, they are. I cannot listen in on you when you're in a breakout room, nor can anyone else. I put you in there. You're going to know who's in the breakout room. You're going to know if someone enters the breakout room. You can signal the mediator to come in when you need him. There's a chime that you're going to hear when anyone enters the breakout room, although I find that attorneys are talking so much when I come in, they never hear the chime. And I also have the ability to create 10, 12, 15, 20 breakout rooms, as many as you need for you, your client, the other parties. I could put you together. I could take you apart. I can move you around. I did it earlier today, where I was moving people around room for room as the discussion was required. And in an emergency, if I need to close all the breakout rooms, if I have to, I can shut them all down immediately. In terms of the benefits of virtual ADR, and I think, you're really getting a feel of that at this point in time, business continuity. We saw this coming. I saw it coming. NAM was prepared for the pandemic 4 years ago, and we started using this in mediations and arbitrations 4 years ago. But for all the reasons that I talked about, fear of the technology, fear of the cybersecurity, does it work? People didn't use it. But I started, recommending it as a commercial arbitrator, so we didn't have to travel cross-country for a Frey-Dauber hearing, and it worked out perfectly. It does work out perfectly with NAM because we have an IT department always behind us. It allows the parties to continue mediations and arbitrations no matter what the circumstances are. As I said, I've done, well in excess of 100 at this point in time. It has been business as usual for us from the day that NAM's office is closed. So whether it's a hurricane, some type of other natural disaster, anything, you're going to be able to continue arbitrating and mediating. Flexibility in scheduling, cancellations. Well, we all know that you as attorneys accommodating your schedule, accommodating your client's schedule, and accommodating the neutral schedule is a challenging task. Scheduling issues often delay the process of setting up a mediation or arbitration. And the flexibility that you have by attending virtually, and I had attorneys saying this to me, why would I travel any longer? Why would I have my client, travel from Long Island to Manhattan or from, Wisconsin to New York, where they can be virtually present? That flexibility makes scheduling much easier. And if a party isn't able to attend at the last minute, we're actually seeing that scheduling is easier now. Cancellations are dropping. The reason they are, look, something happens the last minute with everyone, okay? Happens with attorneys. Gee, the judge called me in the morning of the mediation or arbitration. I found out 2 days beforehand. I really don't want to bust it. Well, virtual arbitration and mediation, you don't have to cancel. You can usually work it into your schedule. Savings in time locally or more significantly nationally. ADR saves you an incredible amount of time. Even if it's local, you're going to spend hours getting to and from, hours that you could be working on other cases, and the cost also to your client, taking those hours to travel to and from the virtual arbitration mediation, it's more cost effective for your client. By having the ability to attend virtually, the need for travel and the expenditure of time, just drops dramatically. Savings of money, well, reduction of costs. The use of virtual ADR, as I said, is going to, cut down on travel, and very often that can be an incredible cost. As I said, I was involved in a commercial arbitration where we had attorneys on the East Coast, attorneys on the West Coast, witnesses all over the country, 2 neutrals in New York, 1 neutral in Florida, and the venue for the arbitration, was in Los Angeles. Well, we were able to do a substantial part of that process by Daubert hearings, motion arguments that were complex, taking the testimony of certain witnesses who we were having difficulty getting to Los Angeles. We saved an incalculable, or the parties saved an incalculable amount of money, and actually accelerated the process so that it was much easier, it went much faster, and the parties were really, really satisfied with it. So will it replace, virtual, the virtual replace face-to-face mediations, arbitrations? Well, as I said to you before, I started off by saying what my prediction is, and I really, every week that I do this, I'm feeling, more strongly that this is, I said, and this is a slide that I used, I think, 12 weeks ago. It's my ending slide. It's going to have an impact. It's having a massive impact because of business continuity, scheduling, cancellations, savings in time, and savings in expense. So what I'd like to just say in conclusion, I'll leave some time for questions. There's nothing to lose by giving virtual ADR a try. The fact of the matter is, I will tell you, the response has been overwhelmingly positive. There has been no negative response that we've had. The only issue that comes up every once in a while is someone's broadband is not great. That can affect it. That's something we can't control. Settlement rates have been the same, and I think it's going to be an incredible option for all of us going forward. So with that being said, I know I've gone to 2:48, which is about, I think, 40 minutes from when I started. And if there are any questions, I would be happy to answer them at this time. Kelly?
Excellent. Thanks, Judge DiBlasi. We do have some time left in the hour, and we've gotten a number of great questions from the audience so far. Again, we want to encourage everyone to ask Judge DiBlasi any questions you might have by entering them in the Q&A widget of the console. And if we end up running short on time here and can't get to them, we'll do our best to follow up and answer your question after the event. So let's go ahead and cover as many as we can now. The first question in front of us is, how do you get the parties to sign a mediation settlement agreement to confirm a toughly negotiated settlement to avoid any morning after second thoughts? Second part of the question is email confirmation accepted by courts to bind the parties?
Yes, well, email confirmations, actually, we've had issues where people have attempted to back out of a post-mediation agreement and they've been enforced by the courts. What I do is I prepare the post-mediation agreement. I incorporate any terms that the parties have as well as the monetary agreement. Then what I do is I screenshot it and I email it to the parties within 15 minutes after the not after the arbitration, after the mediation, and they will have it. So it says specifically on it, with the consent of the parties, this is signed virtually, and that's how I handle it.
Okay, great. Another question here is, how am I assured that my adversary cannot hear my discussion with the neutral? And they note, I have encountered this problem with the court on Skype.
Well, that's a really good question. And, as I said earlier, we use the Zoom platform with our enhanced security measures. We rarely use Skype unless a party requests that we do so. From our perspective, I think that's an entirely legitimate question. One of the reasons that we use our platform is we are assured that no one is going to be able to overhear anyone else's conversation because there's a continuous monitoring of it, and the mediator and neutral can see everyone, they know where everyone is, and they know that they're in different channels. I don't want to get more into the technology of it, but in Skype, you don't have that. You also don't have breakout rooms really in Skype. Well, you don't have them in WebEx either, for that matter. BlueJeans does have it.
Great to know. Some questions are flooding in here. The next one we have is, how do you consent or know parties are aware of rights and responsibilities in virtual mediation?
Okay, well, I think in terms of that, sort of a general question, in terms of the rights and responsibilities, this comes down to is who's your neutral. I have to answer that question. It's hard to answer generically because specifically because it depends upon the situation. But I'm always very careful, as I said before, to find out who's in attendance, to make certain ground rules clear to the parties. And as I go forward, just as I would in the face-to-face, I do it's virtually the same thing. If I had a more specific example, I could probably give a better answer, but that's the best I can do.
Okay, perfect. Someone else would like to know, how do we communicate with our clients during mediation? In a breakout room, separately, on cell phone? Is there another way?
Oh, no, it's so simple, and that's the amazing part of the technology. I create a breakout room for you, and I can create a separate breakout room for your client. I know that a lot of times, just as we would do if you were face-to-face with me, you may want to talk to me out of the presence of your client. So as I did this morning, I create a breakout room for counsel. I create a breakout room for the client. I keep additional breakout rooms open. For example, in multi-party cases, if certain of the parties want to caucus together, it's very easy to do. It's just like you're face-to-face. But in fact, it runs faster. And I often have to tell people, slow down, because nobody's walking around. It's incredible. It just runs that much faster. So it's identical to the process, and all the technology is there for it.
Okay, here's another technical kind of question. If someone accidentally bounces out by leaving breakout or other issues like broadband, how easy is it for them to get back in?
Well, as long as they have the link with NAM, as long as you have the link, all you have to do. I had this happen yesterday, where an attorney's broadband crashed. So initially, I got him back on the link. We got him back on when his broadband went up. When he couldn't do it, we got him in via teleconference. And in the teleconference, I can also put you in a breakout room. So by virtue of being in on teleconference, you enjoy all of the same benefits. And I brought him back in by teleconference because he couldn't get his broadband up. And the mediation went forward, and we actually settled the case.
All right, great. That really does sound simple enough. Another question, do you help us with exhibits, and how do we show exhibits during the arbitration?
Okay, that's a question that comes up very often, and what it comes down to is screen sharing. Now, on your part, it's really very simple, and you can go online and you can take a look at, there's so many great video tutorials on how to screen share, but all you have to do is, for example, let's say you bring up the document on your screen. On the Zoom platform, you're going to see screen share at the bottom. All you do is click on screen share. I walked someone through this yesterday. It shows them a picture of what's displayed on their screen, more specifically the document. You click on that. It comes up on the screen. I preview it, and then I allow it to be shown to all the parties. It's really very simple, but I know it does freak everybody out, but it is very simple. And I'm going to say one more thing. I've done, as I said, so many of these at this point, it's by second nature. I can't speak for other neutrals outside of NAM. We're all trained to do this, but, how someone else does it and another, ADR provider, I can only speak for the training that we have. We know how to do it. Plus, as I said, we have an IT department standing by if there's any type of issue with screen sharing, and they literally can come into a joint session of an arbitration and work the IT problem out.
Sure, that's great. We have a few minutes left, so we'll keep rolling with the questions here. The next one is, are clients separated from attorney discussions with the neutral as is done in an in-person mediation?
Yes, and that actually, for example, the majority of in-person mediations, the attorneys do not want the client present during the joint session. All that happens is I have the attorney come in initially with the client in the joint session. I create a breakout room. I put the client in the breakout room, and then I set up a separate breakout room for the attorney if he wants to talk to me or she wants to talk to me privately, and then I can move that attorney back and forth between those two rooms so he can be in the room with the client, step out of the room, talk to me, which is often the case. It's very simple.
Okay. What if documents that cannot be submitted prior to the arbitration need to be presented to a witness?
Okay, so what if documents, well, that's a great question, and again, the answer is with respect to screen sharing. I mean, if it's an arbitration, assuming there's no objection to it. I had this the other day. There was a document that an attorney wanted to show to a witness that had not been previously provided. The other side had no objection to it. I was able to preview it. He screen shared it, showed it to the witness, showed it to the other side, and we were able to do it. Again, it's as simple as learning how to do screen sharing, and the thing that I would again emphasize, that's easy to learn how to do on your own. But on NAM's platform, we have an IT department that I can get online within 60 seconds to take you through that and help you do that in the event that comes up.
All right, great. Here's an interesting question. Due to technological delay in answering questions remotely, isn't the ability to judge credibility reduced?
I'm going to give you a simple answer on that. No. I think I presided over 300 trials to verdict, jury trials to verdict when I was a judge. And I've done a lot of arbitrations now as an arbitrator. And honestly, you know, people have said to me, well, you can only see the person up to a certain extent. Honestly, from my perspective, maybe someone else will feel differently about it. I do not see any difference. The clarity of the screen is the clarity of the audio and video is so good that for someone who's been doing this for so many years, I just don't detect any difference, and I'm rendering decisions on the cases on a regular basis.
That's excellent. So we have just a few minutes left. We'll take maybe two more questions. The next one we have is someone says, we have a few cases that are ripe for mediation. Some clients come from a low-tech background where the most advanced tech is a flip phone. Assuming there is a virtual mediation, will NAM allow these low-tech clients to participate by being alone in a room at a center with the tech? If not, how can we overcome this tech obstacle of a financially challenged low-tech client?
Okay. As long as they have access to any cell phone, it's very simple. I did this again a few weeks ago. The person can call in. We give them the meeting number, the password. They come right into the meeting as if they were appearing. The only thing is that there's no picture of them. So all you need is a landline or a cell phone. It doesn't have to have video on it. You can participate just as anyone else can. There's just no visual image.
All right, perfect. We'll make this our final question. Thanks so much, Judge DiBlasi, for addressing all of these. This has been great. The final question is, many trial lawyers are concerned about effective virtual cross-examination. What has been your experience with that relative to face-to-face?
You know, and again, I'm going to say this as a former judge and as someone who's arbitrating, you know, continuously now. I just do not see any difference on cross-examination. The difference that I am seeing is people are a lot more courteous during the course of the process. And I think by virtue of the fact that the witness sees me, knowing that I'm the arbitrator, looking them in the eye, it does have, I believe, a chilling effect, which has an effect on the witness. Not that they're lying, but they tend to take it, I think, and I hate to use these words, they take it more seriously, and I think they're under a lot more pressure because they're looking who they perceive to be the judge right in the eye. And that is something that would not happen in a courtroom and would not necessarily happen during an arbitration where, depending upon the position of the party, they may not have to look at me.
Sure, that makes complete sense. So on that note, we are getting close to the top of the hour. Thanks again so much, Judge DiBlasi. This has been a really informative session. Appreciate all the valuable insight today.
It's absolutely my pleasure, and I got another mediation starting in about 5 minutes, so perfect timing.
All right, perfect. We'll let you back to your day then. Thanks also to law.com for their support, and thank you to everyone in the audience for making the time to join us. We hope you found this discussion useful. Just as a reminder, all participants will receive an email shortly after this event with detailed instructions on how to receive your CLE when it becomes available on June 18th. You will also receive an email 1 week from today with instructions on downloading your state-specific CLE certificate. And remember, this webcast will be archived so you can refer to it later if you would like. So with that said, thank you all again and have a wonderful afternoon.